I hope I'm doing this right. It's going. It's going. Okay. If you can all turn your microphones on, please, because I turned the streaming off, please. You just did the recorder. Okay, Chairman Cavelli, you have the floor.
I'm sorry. Let me get my jacket off so I can be comfortable. Okay. Okay.
You have it?
I want to call this meeting to order of the Zoning Board of Appeals of the Village of Airmont on this date, Thursday, January 11, 2018. I'd ask everybody to rise and join me in the Pledge of Allegiance to the flag. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now, for once in a million years, I call this meeting just 30 minutes prior to when we usually have the meeting at 8 o'clock. And we may not take the entire time to have a short discussion regarding procedures of the board. And I think that the main thrust had to do with, and Dan, tell me if I'm wrong, Mr. Krashow is the board's attorney, and the question is, I believe that under state village law, for any application, that the board has an option, or boards have an option in New York to render a decision at the end of a public hearing, or to maintain some time for thought and further discussion, and I believe has up to 62 days to render such a decision. Is that correct?
Yes, but I do want to add a particular caveat with regard to this type of application. This is...
I wasn't even referring, just in general.
In general, yes.
But be specific, please. Yeah.
Okay. This is not an application for a determination of a variance, either use or area, or a special permit. It's for an interpretation. It is technically, while the board is free to allow public comments, that's not the intention. It is really focused on whether or not the board agrees with the interpretation rendered by the building inspector / code enforcement officer, in this instance with regard to the number of students that are allowed to use the property known as Central UTA.
Okay. Now, I thank you. In general, for non-interpretations, applications asking for waivers from our zoning law. So let's say at the end of the public hearing was declared closed at a particular meeting, and the board felt that they just were not able to, at that moment, render a decision. How does it work, procedurally, given that the state allows 62 days? Is the board just to remain apart from each other for 62 days, or 30 days, or 14 days? Or is it up to the chairman or chairperson to call an additional meeting for further discussion, which of course would be open to the public? I mean, what would be the purpose then? Just have everybody silently have individual thought at their domiciles and then reconvene?
Well,
At the next at whatever, the next or the one after that? How does this, I don't know what other municipalities do.
okay, it depends on the circumstances. If at the end of the meeting, the board needs more information, either from the applicant or one of the board's professionals in order to render a determination, they can seek that. And once they receive it, they can either convene at the next regularly scheduled meeting, which wouldn't be typically more than a month later.
Right.
Or they could, if time required, seek additional time from the applicant, or a special meeting in the event that the applicant didn't consent to giving the additional time, then they can have a special meeting. I don't know if that completely answers your question,
Well,
but it's really fact
very
specific.
close to complete.
But once again, this isn't technically a public hearing. This isn't
It's an
exactly.
interpretation. And again, I want to make it clear, I was really not referring to what's before us on the agenda this evening.
Okay.
I think the main reason for just meeting a little earlier was just to get a better understanding on how to go forward in the future should,
Yes, it is not. Let me put it this way: it is not uncommon for a zoning board to hold a public hearing on an application, typically for an area or a use variance, and need time beyond that initial meeting to be in a position to render what's required under the law, which is findings of fact and conclusions of law. The details necessary. It's hard to do that sometimes just off the top of your head at the initial meeting.
absolutely. In my, in my experience, years of experience on this board and on other boards, to be really fair to the applicant, to the public, we may take this
And the
opportunity
process.
in the future to give the best decision possible and, best consideration of evidence that has come forth. Do any members of the board have any questions regarding, procedure and, delay and vote as we're talking about it? Mr. Katz? You have a question of,
Dan,
Go ahead.
Dan, what happens at the end of this session if we can either agree or disagree with the building inspector? Is that correct?
Not
And-
necessarily. You may need more information.
Okay, at the end of that process, when we have all the information we can possibly use, then we have to decide whether we agree or disagree with the building inspector. That's what we're going
Yes,
to ultimately decide.
and you
Then what
should-
happens? Let's say we agree with the building inspector. Then we'll have the applicant has to ask for a variance, or the applicant is dismissed, or what happens
Well,
then?
the applicant already has in process an application to the, if you feel that I'm prejudicing anything, stop me now. Okay. The applicant already has an application pending to go before the planning board to seek alternate relief in the event that this board comes to the conclusion that they believe that the building inspector made the proper determination.
What does that mean? I don't understand.
In other words, they have an application to appear before the planning board for site plan approval to
Approve what's
to
currently
approve
there.
what's already
Not
on.
a- it's, I don't mean to enter into a colloquy about this, but it's.
No, I invited it.
Okay. It's not exactly alternative relief. What we are actually before the planning board for, and I will quote you from the narrative. It was actually a joint decision made between the applicant and CBRC that we go before a part of the planning board to obtain a determination from the planning board as to the number of students who can educate in its existing buildings. In other words, what we're seeking here for the appeal this evening is a determination as to whether the building inspector is correct with respect to the actual number that is there now. What we're seeking from the planning board is a determination as to the maximum number that can be, okay, which is slightly different things.
Well, I think we're clear on that.
Okay.
I appreciate that.
But that involves potentially site plan approval.
Potentially, yes.
If there's, I just wanted, a little conversation regarding, the procedure with the, the permission granted by village, state law. Okay.
I think also to answer Mr. Katz's question,
And
which is,
I'm sorry,
Stephen
Stephen
Marshall.
Marshall, my co-counsel.
This is
A pleasure.
The applicant has not decided whether or not, couldn't decide whether or not to appeal the decision of the ZBA. I just wanted to be clear, since you were asking what are all the possibilities. Another possibility is that the applicant could choose to litigate whatever adverse decision there was in the law. So that's another possibility.
Okay, so that's possibility number one.
Okay, go ahead.
Now I have a question for our council.
Oh, sorry.
If a board is sitting and concerned about litigation, do they have a right then to go into executive session, as this would be a different position than if litigation wasn't discussed?
Well, I do think that the applicant's co-counsel has now put that on the table.
Thank you.
And I would suggest to you that we're not talking about litigating over these proceedings. We're not talking about if you're doing something illegal in the conduct of your meeting or anything else. We're talking about everyone's right to appeal an adverse decision. So no, there is no threat of litigation at this
Excuse me,
time.
Counselor.
Yes, ma'am.
Your statement of objectives of what could occur included an action against the determination.
Not just included
except that
it,
every-
but actually was the first line
Thank you, Counselor.
of.
That's what we
Hold on,
heard.
hold on.
We didn't even need to
Hold
go
on.
here,
Hold on,
We weren't even getting in here. We're
I
gonna have a
understand
generic,
that,
a
but
generic
this
discussion on
this has been opened up. Okay, first of all, as the board well knows, any applicant who appears before any board in any municipality always has the right to litigate any adverse result. As a matter of fact, not only that, but people in the community who have standing, who are sufficiently affected, also have the right to litigate any adverse result. And to say that the first thing that Mr. Barshoff said was litigation with respect to an adverse result, well, that's kind of the only thing that we've got other than the alternative, other than perhaps the planning board proceeding.
Perhaps.
The notion that the notion that an applicant would have the right to appeal would justify a board in going into executive session in order to discuss the merits of an application is not appropriate.
Right.
Okay?
Excuse me, that was my question, and Ira, you should know better. It wasn't on this case, it was general. We were talking about general board
I
procedures.
appreciate the qualification.
Okay, well, it's everything
I-
gonna jump.
I
The
assure-
general
I
question was.
assure you that, this is all general. It has zero to do
With
with
tonight.
this agenda item.
Forgive me, because it was my statement that was called out, and I'm only here on this application.
Okay, but I just want you to know, that is, for the record, bottom line truth. I had spoken to our, board's attorney, last month, and some of the members, raised question about, state village law and the procedure, because I would think, other than where we needed to adjourn a public hearing and request additional information, this board, and I've been on this board for many years, we've rendered decisions right at the end of a public hearing. So we've heard that other municipalities routinely don't, and we just wanted to have a general feel to how this group of lay people go through, the procedure. That was it.
We can appreciate
Nothing to do with it, and that's where it stands. So, you may.
Thank you. My question, I didn't get to my real question yet, was, I understand now that if we approve or affirm the building inspector's decision, then the applicant has a right to will either proceed further with the planning board, or maybe if it decides litigation is appropriate, they'll do that. What happens if we disagree with the building inspector? Is that the end of the case? If we say we don't think the building inspector is correct, what happens next?
It depends. It depends on how far you go in that ruling. Because from what I read, they're still seeking additional occupancy than what they believe, and once again, correct me if I'm wrong, or you disagree, than what even they believe they're entitled to. Meaning that they would still, I believe, have to go to the planning board for that additional occupancy and the potential site plan amendments that
But
would
now in
entail.
this request, right? In other words, if they want to do something additional, that's a new application for something, whatever they want to
They'd
do
have to go to the planning board.
for that. But
Community
as far as,
Design Review Committee, that.
yeah, okay, that's a regular routine, but what about this application right now? If we agree with the
Not
building
an
inspector
application.
with this interpretation request, it says application for an appeal, so, if we agree with the building inspector, they could do what they said they could do, their options. Now, if we disagree with the building inspector and vote that no, it's not correct what he decided, then the case is over. This case is over. Whatever other procedures have to go for other matters, that's a different question. But this procedure would end if we decide against the building inspector.
Well,
Not that we will, we won't. I'm just saying if.
I would not, I'm going to use, I think, Mr. Emanuel's words. Either the applicant or the public could legally challenge this board's determination if it was adverse to their interest.
Mhm.
So it wouldn't necessarily be over.
That means
Does
litigation.
the town have the
Right,
ability to, as a whole, have the ability to appeal a decision?
Does what?
Does the village have the ability to appeal a decision, like another board or village as a whole?
It's a very interesting question. I cannot believe we're getting into this, but there have been cases where other boards of a municipality have sued other boards of that same municipality disagreeing
Well, they wouldn't be
with
suing the board. they're
that
just
other
appealing
board's
the decision.
decision.
Well.
Because they're not suing the board, they're just appealing the decision of the board, right?
Well, it's the same thing.
It's a suit that relief is being asked for. Well, anyhow,
Anyways, what's that?
Let's move
Let
on.
me just say finally. So that
Let's
means
go
if
on.
we
For any of
disagree
the lawyers
with-
in the audience, you were getting CLE credits for
So if we disagree with the building inspector, that solves this case unless someone sues us. Is that it? In other words, appeals from our
No.
decision. But procedurally,
Let's
we're
not
done
even-
or we're not
where are we
done.
going?
I want to know what's happening.
What's happening
We
is,
haven't heard anything yet.
I'm going to hear testimony from, what are you going to say? We're going to hear testimony, we're going to hear a presentation of this case by counsel, and we'll talk about it. I mean, I can't tell you what's going to happen. And if we say
That's probably why I didn't ask you the question, I asked the council.
he's not going to know what's going to happen, we haven't had a discussion.
Pins and needles.
Okay, never mind, we'll see what happens.
Let's see what happens. All right. Suzanne, could you call the roll, please, for the record?
Sure. Member DiFrancesco,
Here.
Member Piccarelli,
Here.
Member Katz,
Here.
Ad hoc Member Ryan,
Here.
Ad hoc Member Carbone,
Here.
Chairman Cavell.
Here.
And note that Member Meyer is out of the country.
Okay. All right. All right.
Marty,
Marty.
you need to appoint another vote.
One of the ad hoc.
One of the ad hoc
As a
needs to
voting
be
member.
appointed as a voting member.
All right, Mr. Ryan? You're hereby appointed as a voting member on this agenda item for the record. Okay. There are minutes that were presented to us. The last time we met was sometime when the flowers were blooming.
In May.
It's been a slow several months.
Well, that's because of the
So-
moratorium.
I hear a suggestion on what we should do with these minutes from all the board members, or?
Well, you definitely have enough members who are present.
I make a motion
At
to
that meeting.
accept the minutes as presented
Just to be clear, from Thursday, May 11th,
from
2017.
Thursday, May 11th, 2017.
A second to,
I will second that.
okay, we have a second. Any discussion on the motion?
Just to be clear, the voting members could be Mr. Cavell, Katz, Ms. DiFrancesco, and Mr. Piccarelli.
We were present.
Yes.
All right,
We can move along.
so,
Now we go to our interpretation.
All, you didn't.
Well, there was a motion and a second.
second.
Second,
Yeah.
I need all in favor.
are all in favor?
Aye.
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 Okay. Number 6 on the agenda is the actual reason for us being here. It's an interpretation. Application for an appeal from Central United Talmudic Academy of Muncie for an interpretation from the building inspector, code enforcement officer's determination for a violation dated August 5th, 2017, that the owner representative admitted at the May 9th, 2017 Community Design Review Committee meeting to operating a school for 200 to 300 students. 236 Cherry Lane does not have a certificate of occupancy to operate a school for 200 to 300 students. The property, which based on the applicant's submission, is purportedly located on the east side of Cherry Lane, approximately 500 plus or minus feet south of East Blossom Road. The lot is designated as section 56.17, block 2 and lot 2 on the town of Ramapo tax map. Property is located in the R40 zoning district and is comprised of 21.4332 acres. The street address is 236 Cherry Lane, Airmont, New York, 10952. Mr. Crashour, can I ask you a question? Prior to proceeding.
You can ask, we'll see if I'll answer.
You'll answer it, it's an easy one. Procedurally here, and in all fairness, I want to hear testimony. Obviously, I'm going to hear presentation by Mr. Emanuel and his co-counsel, but I want to hear testimony from, the building inspector himself. Shall he be the first one to speak? I just want to do what's appropriate and proper here. So, what would your opinion be as opposed to Mr. Emanuel and counsel presenting the issue?
I mean,
Or it doesn't matter?
I don't know that there's a particular methodology behind this. Both parties will be given an opportunity to be heard. I'd actually leave it up to the applicant to decide what they would prefer.
Up to you, Mr. Chairman.
Use the floor, Mr. Mayor.
Okay, thank you.
Thanks.
I would like an opportunity, however, to respond to the building inspector if necessary.
Okay.
Okay. Thank you. Since we're now on the record for this particular application,
We are.
let me introduce myself and my co-counsel, Ira Emanuel, New City, one of the attorneys for the applicant of Central UTA of Muncie. I have with me Stephen Barshov of Side Package Moselle, New York City. He is my co-counsel on this matter. As the board is aware, this is an appeal from a determination of the building inspector. This is not a variance application. You understand that there are different rules that apply to this and different standards for you making your decision. I'm confident the board understands all of that. So we'll get right into the facts here and the merits of the case. The property that we're talking about here was known for many, many years as Camp Reddish. It's approximately opposite the Cherry Lane School. Was operated as Camp Reddish for many, many years. Around 2001, a private religious school, a Terrace-based Yaakov Academy of Rotham, applied for and obtained permission from the planning board to operate a school on the same premises. The understanding, of course, is that a summer camp operates about 2 months of the year, where a school operates on the remaining months of the year, and so therefore there wouldn't be any overlap, and things seem to work out well. A Terrace operated its school from about 2001 until 2015, and during that time the school population continued to grow. Originally started at about 160-something students, and by the time the Terrace left in 2015, there were approximately 415 students on campus. During that period when the Terrace was in operation, it also took a number of the buildings that were on the Camp Reddish campus, winterized them, upgraded them, and occupied them and used them for school buildings. All of this was done with the knowledge and permission of the village of Airmont, whether that was done through site plan approval or through the building inspector issuing various permits or acknowledgements. It depended upon the particular situation. All of that was fine until 2015, when the property was sold and purchased by the current property owner, which is the applicant, Central United Talmudical Academy of Muncie, or Central UTA. In 2016, Central UTA began operations at the site with a little fewer, approximately 330 students, down from the 415 or so that the Terrace had. Soon thereafter, Central UTA also indicated that it was going to be filing at some point significant expansion plans. At some point in, I believe, May of last year, while we were having discussion with CDRC about these other plans, we discussed the fact that there were approximately 400 students at the site. It is this quote-unquote admission that forms the basis for the violation notice that was issued by your code enforcement officer having claimed that the school suddenly was operating at far higher capacity than was permitted. That had never been an issue during all the years that the Terrace was there, but suddenly it was an issue now. We appealed. You have before you, and I'll recognize that you just received a rather large package of materials from my co-counsel. One of the problems that we have, and by we I mean all of us, okay, we, Central UTA, Mr. Zumo, the board, everybody, is that the records with respect to this particular piece of property appear to be incomplete or fragmented. It has been very, very difficult to obtain information, despite the best efforts, by the way, of Ms. Carley, who has been very, very cooperative with us. We spent the better part of a month going through a hard drive that was presented to us that purported to have documents with respect to what's this proceeding. We don't know if that hard drive was complete. But what we have done is we have gleaned as much information from that hard drive as we could.
Who's the hard drive from?
From the village.
And why would you suspect that?
We had FOIL. We had put in a FOIL request for all records regarding the planning board, zoning board, and building records with respect to this particular property for the period in question. We would hope that there would be complete records available and be made available to us.
You said you think they're incomplete. I'm asking why you think that.
Well, we believe they're incomplete because we've had discussions with the prior owner, who has assured us that there were various permissions. In addition, we have in here, and you probably haven't seen this yet, but we have a letter from the prior building inspector, Ian Smith. Mr. Smith provided us with a letter in which he says, at paragraph 8, eventually a terrace topped out its student population at the site at approximately 400. At no time was the student population increased nor buildings used without proper permits and certificates from my office.
Excuse me, Mr. Emanuel. Ian made that statement on your request, but are you advising this board that Camp Regish never kept copies of any paperwork as a business?
Well, I actually, it's interesting that you asked me that question because I have contacted Rabbi Fink, who was the principal of the terrace. Rabbi Fink actually is recovering right now from a fairly large heart attack that he suffered about a month and a half ago. But even prior to that, I had contacted him. His records are in storage because right now he does not have a permanent location for the school, and he has been unable to go through his records. So we have attempted to get records through him.
Okay, because I'm a little, I don't want to say surprised that a building inspector can remember doing all of this and yet not have any records in Village Hall on it, and it's a little surprising.
Well, I would suggest to you that building inspectors, and Mr. Zumo can speak for himself, but in my experience, building inspectors are usually pretty good about remembering who's in compliance and who's not in compliance, and who's a perpetual offender and who is not. I know that I have a pretty good memory with respect to all of the applications that I have been involved with over longer than I care to remember at this point. I know also that board members have very good memories about what has gone on. So it does not surprise me, nor do I think it should surprise you, that Mr. Smith would recollect that there were no violations and no occupancies in excess of what was permitted.
I think the surprise on it is looking at all of the COs and the time periods that you did so nicely include, because I've gone through this package electronically. God bless you for putting it together. The time periods that these would be occurring, and that there are COs for pool gates and plumbing, but not for other things. It just is not, I appreciate Mr. Smith's letter. It just doesn't seem consistent with all the paperwork. It's only a comment.
Is he here for the board to cross-examine?
No, he's not.
Did he review the records that you received
Guys,
from the
let's go
town?
through
One person.
members, let's go through the chair to be recognized so we have.
Oh, sorry.
Go ahead.
Oh, I'm saying, I guess I'm just having a problem with your saying the records were incomplete, and I'm just not sure where your basis for that is. And you're referring to this record or this letter from the former town inspector. That being the case, did he inspect the records that you received and confirm that they're not accurate?
No, he has not looked through these particular records. Okay. This is based upon his recollection.
All right. Why don't we let Mr. Emanuel complete his presentation, and then we'll go from there, so.
Okay. There are records that we do have here. And there are records that indicate that the village and the village's inspectors had full knowledge of the fact that there were 400 students at the terrace location. We have records that were filed by your fire inspector with the New York State Education Department, in which he specifically uses that number of 400 students. Mr. Smith, the building inspector, was a recipient. In fact, he was required to receive a copy of that. We have a CDRC minutes that talk about 400 students being at the location while a terrace was in operation. And those CDRC minutes, that admission at CDRC at that point did not generate a notice of violation. So you have a course of conduct here from prior village officials that indicated to all around, okay, including, by the way, the subsequent purchaser, the current owner, that there was no difficulty with having 400 students at this particular location.
You have more?
Not at this point.
Okay, thank you. Mr. Zumo,
Yes.
who was the village's building inspector. How do you address
Well, I'd like to address some of Mr. Emanuel's
Mr.
points.
Emanuel's thoughts here? And,
I did read the letter from Ian Smith, and there will be attachments with it. And I do appreciate his comments that building inspectors have phenomenal memories. And I'd like to point out that in paragraph 1, Mr. Ian Smith stated that he worked from January 2005 to June 2015. If he has such a phenomenal memory, he would remember that he worked till 2016. So I'm thinking that he didn't actually write this letter, that somebody fed him this letter. That's number 1. Number 2, the CDRC meeting, which he is addressing in point 13, October 14, 2014. I have the minutes of that meeting, and Ian Smith wasn't there. So I don't know how he remembers all the things that happened at that meeting. So this is basically produced by somebody else, and Ian signed it.
I'll state for the record right now, I wrote the letter based upon information that was given by Mr. Smith. And Mr. Smith, down your belt, please. And Mr. Smith, okay, did not accept the first version that I wrote because he felt there were things that I had characterized that he was not comfortable with, that I had not gotten quite right from my interview with him. Okay. So although I wrote the letter, these words are adopted by him, and he's quite comfortable with what's here.
okay. I take you at your word.
So there's nothing nefarious about that.
I take it at your word.
As for the other exhibits, I went through every exhibit that's in here, including the resolution, which is the only factual one that actually gives a count on the number of students of 167. It says specifically no more than 167 at any given time.
All right, so I think you answered, an initial simple question.
As for the inspections that were done,
For population on that property in that school is
167.
okay. The number 400. I know you can't sit or get into somebody else's thought waves. Where did? Well, I don't like to deal in speculation. Where was the number 400 divined from?
I honestly can't tell you because
Wait.
we've never actually, I've done multiple inspections on that property, as has our current fire inspector. We've never been allowed on the property when there are students.
Why not?
For reasons unbeknownst to me.
That's not.
I've never been on that property when there were students.
Please, audience.
With the numbers that we have currently, because if our fire inspector was here, he could tell you we counted chairs. Where there was no bodies in there while we were on site. The number that was probably given to Mr. Wepler was probably given to him by somebody else. Because I don't know how he could have counted 400 students.
Okay.
As for the inspections that were done, that are all included in here. I went through every inspection and pulled every building permit. Many of them are for things that don't have anything to do with the school. Almost all of them don't mention a building number or identify a use for that building. So they don't verify anything to do with the school or an increased headcount. The receipts for permitting, virtually all of those don't mention anything either. Very few of them even have permit numbers on them.
All right, can we go back in time a little bit to, when the other educational organization was operating, Paris Space Yakov, I believe? Okay. When they were operating, they had a certificate of occupancy to
Yes, they do.
operate a school,
Yes, they do.
and for,
2 modular buildings and 2 converted buildings for 167 students.
that was my next question, for how many? 167?
Yes.
And we have that
Yes.
recorded here at the village.
In addition, I found while going through paperwork, we have 2 violations that were issued against the school 1 month after they got the determination for 167 students. One is for not hooking up to the fire system, and the other one is for occupancy and certificate of use. They did not have certificate of use or occupancy for
That
buildings.
was
they were
the,
using.
Terrace Space Yakov.
Yes, it is.
All right, well,
And that was
What year was that, sir?
9/6/2001. They were supplied to you, right? You got copies?
That's in the building department file. I can't speak
I
to
just
that.
wanna punch through,
Yeah,
you
we-
know,
By the way, we don't have those.
you don't.
We don't have those.
Do you have my copy?
All
Every
right.
rabbi
Yeah,
thinks
you can have-
boxes.
Could be.
We'll make sure that you do. All right, Mr. Zuma, let me continue. I
Well,
have no questions. What?
Okay, now, just an example.
For the record, we just
We
got
got them
these
today,
today.
actually.
We just got them this afternoon.
Apologies for that.
Sorry.
And I think, Mr. Chairman, about this issue of records, part of our understanding of why the records are incomplete, and of course, we're not the custodians of the village's records, is the village's own staff's statement that records were apparently somewhat disorganized, hard to locate, did not appear to be complete. This is not our intention. This is what was told to us. So, to cast aspersions by influence that somehow or other we're responsible for not having a complete set of the village's records, we provided what we felt was relevant from what we were given. If there are more documents, we would be happy to review them and include them.
For the record, am I allowed to say something? As the clerk? One of the issues is there were several tax lots, and I even went to the town of Ramapo, who couldn't even look up the old tax lot numbers because they don't have access anymore. And I went to Rockland County Planning to try to get the information. So I think some of the issues, and I can't speak for building, planning, everything was together. There was one document I found in a box upstairs, but everything else was in one place other than the digitized disc of maps, which I personally copied myself and provided to them. And I can attest everything was provided.
As for the building department documents, we have them on multiple addresses. Because the school was originally registered as address 212, Cherry Lane.
All right, can
The
you
camp was
explain,
236.
can you explain for the board and for the public, the differentiation between the two addresses, what do they mean? What do they attach to?
They're different lots, they're subdivisions in that
Okay.
lot.
All right.
According to the records we found, that lot was as many as 6 different lots, merged into 4 different lots, and the last set of Ramapo records, 3 lots. This was also verified by the Rockland County Sewer District on a document we received this week, that because of the merger, there's an ESA issue, an environmental sensitivity issue on
And
the
I
lots.
did provide that to you.
Yes.
All right, I want to get back, I thank you, I want to get back to, you know, throughout these, you know, documents and meetings, and we're going back, 16, 17 years, you know, it's a long span of time, you're right with your word. You know, I see, you know, 400 here, 400 there, but I do see 167 or 200 to 300. You know, it gets, so I went through all of this, and, you know, like, there still remains no, or there is not an existence of a certificate of occupancy for that larger number, just for 167, is that correct?
That was the only document we found on both addresses for 167 students.
Okay. All right. Laura, you have a question?
Yeah, on the package that you gave us, April 19th, 2001, which was the Lennon Jackson letter to members of the planning board for the initial site, prior to the initial approval. In that letter, it actually states that the yeshiva be constructed to serve 110 children initially from grades nursery to 8, although I believe now it goes to high school by some of the letters on the fire report. Eventually, it's anticipated that 400 children will be served by the yeshiva. That 400 number appears back in 2001, which, when it was approved, was rejected and saying a maximum of 167. So, back in the beginning, when they asked to go to 400, it wasn't approved at that point. It was approved and it was handwritten into the final until it was taped in, not to exceed that 167. But that is the first place that I see this 400 number appearing and being rejected by the village at that time.
That is not, I believe, an appropriate review of the facts.
Right.
First of all, there is no statement that I could find anywhere indicating that that was rejected. What you had was a statement that eventually the school would reach that number. There is no record that that was the number that was sought at that time. So therefore, the conclusion that 400 was sought and was rejected is not borne out by any evidence before you. Secondly, the language that is in there is not mandatory. The word should is in that decision about 167. It says it should be 167. Now the word should does not mean must, it doesn't mean can't be anything else. It means it should be 167. Should meaning what? Meaning that there could be circumstances that would arise in which that number could increase. What types of circumstances? The circumstances that occur, which are circumstances where a property owner came to the building inspector and said, we're not looking to add a new building, we're not looking to increase the amount of buildings that are on the site. We're going to take space that we have, we're going to weatherize it, we'll weatherproof it, we'll do this, we'll do that, and then we'll put more students in there. The issue that is before you is, does the building inspector have the right, the authority and discretion to require or not require an amendment to a certificate of occupancy and a site plan approval? If the building inspector determines that this is just a change in weatherization and so forth, does the building inspector have the authority to do that? This building inspector apparently doesn't believe that that's the case. But he wasn't in office then. The one who was in office has written the letter, signed the letter, whether he wrote it, whether he adopted the words or not. He made quite clear what he did. And the paper trail supports that all the way through, at least to the extent that we found. We haven't found anything to the contrary. The only thing that is found to the contrary is back in 2001, which says that you didn't have what you needed. Now, if we didn't get it, then how the heck did this building and this group school operate since 2001? The building inspector has come in and said to you today, 16 years ago, they didn't have a certificate of occupancy. Okay, so what do you mean, for the last 16 years, the school has been operating illegally? I don't think so. I think what happened was, whatever was issued was cured. The records are not complete, unfortunately. And what you have is a school that went and approached the building inspector at every step and turn and said, this is what we want to do. We want to do this, we want to do this. The building inspector says, okay, and then the fire inspector comes in and says, yes, this is the number. And I don't care whether or not he counted kids or counted seats. He made a determination that there were 400 students there. And there's no evidence in the record, nor could there be any evidence in the record, to show that he did something irrationally or crazy. Those numbers are real. And not only were those numbers real, but we've provided to you the information that was provided to the state. And every year they turned around and said what the number of enrollees were. And it started at 200, it went up to 300, and we provided those records to you. This wasn't hidden. It wasn't done by dead of night. Everybody knew what was going on. And my gosh, it's across the street. It's not like it's buried somewhere. Okay? So these are the
Right, right,
facts.
right.
Nobody's arguing the fact that there's 400 students at the school, correct?
I don't know what people are, I know that
Well,
my
I'm just
client has
saying,
been
that's not
cited with
the
a
issue.
violation saying that they are operating unlawfully. They come before the CDRC and willingly disclose it 3 years ago.
But that's not what we're debating here,
We're
right?
here to-
Nobody's not arguing with you that there's 400 students at the school, am I correct?
No, what I'm saying, sir, is that there have been 400 students for a long time. There have been progressions going all the way up, and what we are saying is it was lawful all the way. And to turn around and say today, oh no, you're limited to 167 that was imposed 16 years ago, is to jump from 16 years to today as if nothing happened in between.
But just so I'm clear, is there's no dispute that there's a 400 or more, plus or minus student population at the school. That has been for 16 years.
Correct.
But the
Well,
original
not for the
but-
entire 16 years. It started at a much lower number.
Correct.
Okay, as indicated, grew over time. By the time the terrace left, and for a number of years prior to the time the terrace left, they had 400 students.
But the original C of O is for 167 students.
Well, you
And
know,
has that ever been
it's
appealed
well,
for an application to increase
it's
that?
interesting. It's interesting because that original C of O, okay, would have applied to those original 4 buildings that they were using, but they added the use of buildings over time.
And that
And
being
did
the
they
case,
get
my-
approval for
I
that?
guess my-
Well, according to Mr. Smith, they did, but we can't find those records. And and not only that, but for all those years they were unmolested.
But should they have?
Is a municipality
applied for an
ever
increase
stopped from
of their
enforcing
CAOs
its
during
own?
that time?
Well, actually, there are ways for that to happen.
Does a
And
municipality
I'm not going to make that particular charge tonight.
What did you
Well, I'm
just
not
say?
asking for you to make that
So
charge.
I guess,
I'm
did they
asking
ever
a
apply
simple
for an
question.
increase in the certificate of occupancy?
I'm sorry?
Was there ever an application for an increase in the certificate of
One
occupancy?
doesn't make application to increase the certificate of occupancy. One makes an application for the use of a particular, one makes an application for a building permit, if a building permit application is necessary, based upon the type of work that is being done. And if that building permit is closed out, then a certificate of occupancy is issued, and it doesn't necessarily indicate the number of occupants.
I have a question. Thank you. On that subject, a commercial establishment, there is, this building that we're sitting in has a maximum occupancy.
Correct.
With regard to fire safety, et cetera.
Correct.
The school, this property, okay,
Mm-hmm.
had been evaluated. But had it been evaluated when this ownership took place in, 2016?
Correct.
Okay? What happened in 2016 when this ownership took place, this transfer of ownership?
Was there an inspection on the property?
With respect to their intention to continue to use it as a school, this was expressed to the village of Airmont. Yes?
I have no idea.
You
That was
don't?
done before I came here.
Okay, I apologize
I
for
do
that.
not know if there was a violation search or an inspection of the property. As per the comment about building permits.
Would that be in the record generally?
We found, yeah, it should be. There should be a violation search somewhere based on the transfer of title.
Well,
Violation search is usually done by the title.
Mr. Emanuel, did you do the closing?
No.
Are you able to get in touch with the attorney who did the closing?
Probably.
Have you ever approached that attorney as to whether or not a violation search was done and anything issued in
There were any
There was-
violations that were issued? No. There were no according to my client, there were no violations that were identified to them at the time that they,
No, was a
acquired
violation
the-
search
Was
applied
a violation
for?
search done? No, violation search was done? Violation search was done, I'm advised.
So you can get the board a copy of that?
Sure.
Mrs. Will, if they were to apply today for a certificate of occupancy for 400 students, would they be granted? You've visited the property a number of times.
That's not up to me. That's a determination to be made by the planning board.
Well, the planning board.
They have to increase the occupancy for the application. That's not a building permit.
Oh, you've hit the number, you've hit the number of the issue here. You've hit exactly the number
The
of the
building
issue.
inspector can't authorize the use or the application from a building permit.
And that is Mr. Zumo's position today, and we appreciate that, but that apparently was not the position of the building inspector at the time that this property was in use by Paris and at the time that the property was acquired by Central UTA.
Which is why I asked if a municipality is ever stopped from enforcing its zoning.
And the answer to that question is yes, under very, very specific circumstances.
And very rare circumstances.
That's correct, but it does
Do
happen.
they exist here?
But it does happen.
Do those,
We don't know that yet.
do you have any reason to believe?
Yeah,
Offer your...
no. Because I don't want to inject that into this proceeding.
Okay.
A question for our building inspector. As you commented, and I couldn't figure out, we have a lot of receipts for COs and building permits. Unidentified for what they are, but a lot of receipts for a lot of work that was done. When a building is to be used for a certain commercial use, i.e. a school, when the CO is issued, I know in a single-family residence, when you finish the house, it's listed single-family residence, maybe 4 bedrooms, 2-car garage. If a building is being used for students for a school, is there a requirement on the CO to stipulate that this is being used as a school as to the fact that it means that the safety issues are all addressed for the students?
It should be.
So the CO should read. So my next question, and this is why I had asked for a map, I'm very confused. The original application back in 2001, Ira, you stated was for 4 buildings?
Correct. 2 existing buildings and 2 new modular buildings.
Okay, and those were the buildings that in 2001 were worked on to be created to accept 167 students and the 10 sewer hookups per Ramapo and everything else.
I don't know the number of sewer hookups,
Well, there's
but
10,
yes.
I checked it on the
Okay.
tax records. Then 2 additional buildings were addressed for the additional flow of students. They needed additional building space.
Correct.
So 2 standing building, modular buildings, what kind of buildings were added on for the school's use?
My understanding is that there were existing buildings that were weatherized.
There were existing buildings that were weatherized. And those, from your understanding from Rabbi Fink, was done sometime between 2007 and 2011?
I don't know the exact dates.
Okay,
For argument's sake, we can take those dates.
I'm just trying to figure a growth pattern where it would affect, okay, and taking it years before you moved in. And during that time period, there are a lot of applications for plumbing, I see in here, and different things, including pool gates, but I don't see anything for the approval. Part of my concerns with all this growth, I would be fair to everyone, is that you have students in a building that I don't know whether or not, although it shows 2 fire inspections, the last one 2015, I don't know if this is really prepared properly for these students to be a building, because I don't see a CO that says these are school buildings. So, although I appreciate the absurdity of a village building inspector allowing and possibly approving and going with an existing situation without ever looking back at the record, because he wasn't with us when the planning board defined this and may never have known or looked to see what the count was. I am looking at an existence that is now located, and by the way, the first inspection was March. If you went in May, it was prior to that, where they went in for a fire inspection and found fault in these buildings, which seemed to have abrupted to this hope where we're sitting today. So I think everyone here on the board is ready to acknowledge that over the years, there have been different departments that have seen the count of numbers by reports that have been put in, which is your first premise. I guess there's a whole opening of whether or not that has any relevance to the fact of what the actual committees decided. But I thank you for that help, and if Rabbi Fink has COs showing those were school buildings, that would have meant that the building inspector did his job to approve additional children on the site, and would give us some stable to support you. I mean, it would give us something that would make sense.
You've hit on what the problem is, okay? And that is the fact that we have all of these inspections, that we know that inspectors from the village have been in and out of the site many, many times over the years. The site was well known to the village inspectors. And operations were going on. Mr. Smith is very clear that he was very familiar with what was going on. Mr. Zumo and his people have been in and out of the site. And certainly any kind of fire or building safety issues have been raised and have been addressed. But the fact that we have all of these inspections, and we can find the inspections, but we can't find the closeout for them, is part of what also indicates to us that there's something missing from the records. Because it doesn't make sense if you have all of these inspection reports and that you don't have the C of Os that were generated, or the rejection of the CO that would have been generated. Because at some point, okay, I mean, frankly, if I found the COs but I didn't find the inspection reports, I wouldn't, that wouldn't have been a surprise to me. Okay, maybe a little bit, but not too much. But to have the inspection reports but no closeout, okay, that leads me to believe that there's records that are missing for some reason.
Well, let me
if I continue, I'm sorry. There is, I don't think, any question but that the buildings are safe. And I don't think it's appropriate to try to inject an issue of safety into this, because there have been so many inspections and there have been inspectors from the village in and out of these buildings over the years. Okay, not just when Central UTA had it, but also when the Terrace had it. Okay, the village is not shy about issuing violations when it feels that it needs to. Okay, you know, probably from yourselves and all, this is when somebody is issued a violation notice by a building inspector, this is where they come to if they challenge it. And so you know from yourselves, from your history, that both Mr. Smith and Mr. Zumo and the other building inspectors that were here are not shy about issuing violation notices when necessary and when appropriate. But getting back to the other point, the fact that we've got these inspections, no building permit that generated the inspection, okay, no CO that closed out the inspection, there's stuff missing.
Well,
You
hold
don't
on.
identify what
Mr.
properties those inspections
Well,
are.
it's all-
Can I ask a
it's all
question
one
relating?
property.
That's a very, very important issue. You do real estate.
Yes,
I do real estate. I know you didn't do this close,
right.
but we already have testimony that the person who did represent UTA upon this purchase sought a violation search from the building department.
Right.
As part of every violation search I've ever seen, within that are the existing C of Os. Why? A, has no one gone back to the attorney who did the closing to find out what's in that title report with regard to the C of Os and any potential violations that may exist there. And number two, assuming that the only C of O in that title report indicates a C of O for 167 students, why on earth would that attorney close on this property without having an updated C of
Well,
O?
first of all, the C of O, that 167 does not appear on a C of O as far as I know. It appears on a planning board resolution. Secondly, not as far as we
That really
understand,
doesn't-
as far as we understand from Mr. Smith, as far as we understand from our conversations with Rabbi Fink, not everything that was done to allow occupancy of these buildings was required to obtain a building permit.
Okay, but let's go back.
And if you don't need a,
Mr.
and if you
Smith,
don't, and if you don't need a
Mr.
building, and if
Smith
you
had
don't need a
this
building permit, and if
conversation-
you don't need a building
You had
permit,
this conversation with Mr. Smith now, recently.
correct.
Why wouldn't that conversation have occurred when the title report was done prior to purchase if it doesn't show up,
Because prior to purchase, we had no idea that the village would take the positions that it has been taking.
So you would allow- you would allow a closing
the village at
without a
one point,
vote?
Dan, you know, because you were at that meeting.
Go ahead.
You were involved in this. You know that the village at one point took the position that no school is there, nor has a school ever been there. And that was reported to the Ramapo Central School District and had the effect of denying busing to the students who attend this school.
When was this meeting?
You were there. You were part of this.
When?
Mr. Zumo issued a letter to the Ramapo
Not
Central
issued a
School
letter.
District in which he said that and because there was on one certificate of occupancy, the word school was misspelled S-H-U-L-L. He interpreted that to mean, S-C-H-U-L-L or something like that. He interpreted that to mean a shul, meaning a synagogue, not a school, and advised the Ramapo Central School District that no school was legally permitted to operate at the premises, and that had the direct result of the Ramapo School District denying bus service to this school. So there's a history here.
Mr. Zumo, could you
Yes, I
respond to
can, I
that,
can
please?
address that. I did not write a letter to the Ramapo School District. The Ramapo School District contacted me via phone and asked me if I had any certificates of occupancy for 236 Cherry Lane listing it as a school. We do not. We have a certificate of occupancy for 212 Cherry Lane as a school.
And when we pointed out,
236 is listed as a camp.
Say that again?
236 is listed as a camp only. On no documentation does it ever say school.
and when it was pointed out that 212 and 236 Cherry Lane are the same piece of property, it took months for us to finally get the property recognized as being a school, because the village, Mr. Zimmel in particular, refused to cooperate and recognize that the school had been in operation at that location. It's the same piece of property and everybody knows it.
Before we proceed, what is this property? I mean, I hear what you're saying.
It is a single tax lot at this point. It was originally, under the old tax maps, a number of different properties. At one
Right.
point there was a subdivision, and some pieces were split off, I think, in the back. But even after that, there remained a number of different parcels until the tax map numbering system was changed. At that point in time, and I forget when it was, the remaining lots were consolidated into a single lot. We have 1,000 feet of frontage on Cherry Lane. It should not surprise anybody if there is more than one address for this one particular piece of property.
Okay. Dan, can we look at that as council is presenting that? That 21 plus acres is, we should just consider that as one property and
I
disregard these two addresses.
I've anecdotally heard it, but I'm
'Cause
not in a position to, substantiate that.
Take a look at your tax map.
Well, what kind of bearing might that have on, how the board is to proceed in making a decision? With respect to, what we've heard here in testimony.
Well, we do have another letter from the building inspector addressed to Ira Emanuel, dated December 6, 2017, which is after the date of the filing of this challenge to the building inspector's determination. And within it, I think it identifies this very issue. Now, on top of that, I'd like to know if that December 6th letter, to be fair to the applicant and their counsel, you did receive a copy of this December 6th letter?
I'm actually looking for it. I don't see it.
I might have an extra copy.
Doesn't mean that I didn't get it. I just don't see it in my file.
I apologize, I think I do have it, yes, the wrong folder.
Yes, that's it.
Let me give you an opportunity to read it.
Yes.
Yeah, this is falling back on the same business about 236 versus 212 and whether or not those are two different pieces of property. Okay, I would suggest you take a look at the tax map. Okay, as far as I'm concerned, that's a red herring.
Okay.
Michael, Suzanne,
Mhm.
I believe we received a letter from so many pieces of paper, from Rockland County, which discussed this.
Yeah, the Rockland County Sewer, letter talks about the old tax lots into one.
Right, I believe
had
Rockland
the
County
ESA.
Sewage letter
Correct.
agrees with, so that perhaps we can put aside one issue at a time, with the fact of the singular tax lot.
Yes, and I actually talked to the assessor's office. They don't know how or why it was into one tax lot. They had no records of a merger. They only could see it as one, because I was trying to find that out myself.
As a side point, just for a point of information, I had 4 clients in the last few years who had 2 pieces of property that suddenly realized they were merged to one without any knowledge or paperwork.
Yeah, there's a
It was
form,
something
and there's
that
no
they
form for
did
these property
when they
addresses.
renumbered. So no, just is what it is as far as getting tax bills. But it's,
But when you read the tax lot and the area from the same tax lot, it does give the full total of everything together.
I need to identify you, sir. I don't know who you are.
My name
And
is Yitzchak Gruber, I'm with the applicant.
you affirm
Central
your
UPL.
words are true and correct to the best of your knowledge?
Yes.
That you're telling the truth.
Yes, sir.
Okay.
This one tax lot number that we have gives the total of 21.433 acre is physically everything together.
and as I said, Mr. Chairman, if this board is comfortable for us not to have that part of the discussion again, it does come through the Rockland County Planning with the same
Rockland
opinion.
County Sewer dated January 3rd, 2018.
Right, so I would like to sort of put that aside so we don't have to discuss it again.
That we look at this
As one tax lot, as per the Rockland County Planning.
so we disregard the addresses.
I would recommend that we do so. Is it, Mr. Chairman, it's up to you, but that would be my
No, it's up to
opinion on
this board.
this discussion.
I'm just one guy here. I just moderate, you know. I'll ask the voting members. How do you?
I think it's just for.
How do you see it?
I think it's reasonable, expect it to be one lot.
I think we should conform to reality as one lot, so it should be treated as one lot.
No?
I agree.
I'll agree too.
Appreciate
Okay.
that, thank you.
Let's move on.
But,
Are you still
yeah, just stay on,
maintaining the floor?
if I could, to just,
Yes,
only,
sir.
and I do
You
apologize.
may.
As
But
I
just
said, I
wanna-
try to read through this, organize it, but it's a lot of paperwork in 24 hours.
We agree, we understand.
Staying with the Rockland County Sewer District letter, which, because this was a posted application, they spoke in on. Okay, as per the publication they saw of the meeting. There is a question, which I guess, Dan, and maybe it should go to you or Lou, I'm not sure, that when
We determined it's.
our building inspector, our past building inspector, assuming that he did what we're saying, because at this point we don't know what he did, but assuming that what he stated is what he did, when he was approving the additional buildings without any site plan or planning board but on his own, was there a requirement or was there any application to the Rockland County Sewer for our sewer adjustments on that? Or should they, or Mr. Zumo, maybe I should ask you, if additional buildings now that were storage are now using for occupancy, which increases the occupancy on the site, which increases the water and the waste flow, should this have been applied to the Rockland board at the time
May
of
I,
these buildings?
may I correct something? My understanding is that the buildings were not used for storage, they were used for the camp, and by the way, the camp had more campers than the terrace ever had students. The camp, as I understand it, had approximately 600 campers. The terrace maxed out at approximately 400 students. In addition, the county sewer district letter is based simply upon the legal notice that was published and not upon a submission of any materials from
That's
this
exactly what I
board.
just said, Mr.
Yeah,
Mayor.
no, I know that. But therein lies the problem with the letter. Because the letter seems to assume that there is new construction that is going to occur. I have to tell you that when I first saw this letter, I glanced at it and said, oh, this is as if it was new construction. They're misconstruing it. It has nothing to do with the application that's actually before us. And it, in fact, does not have anything to do with the application that is before you. Okay, it is based, first of all, it's based on nothing other than a legal notice. It is based on absolutely no information.
Mr. Emanuel, I apologize, but you missed my question.
Okay, I'm sorry.
I wasn't saying that you were right or wrong with sewers. What I'm asking is if a building was approved by a building inspector to house children, which is what I understand it had to be fixed so that the school could have more students. You had two buildings, you have a certificate on one that says a girls' school.
Yeah.
You have,
I think I know where you're going.
well, may I finish that?
Sure.
Thank you. And then you have other buildings that we see evidence that you did something with plumbing or heating. In fact, one of your applications is for a T-trap that has to be checked every 3 months in a kitchen that I know you have the reports on because you're supposed to have them in your business. But putting all that aside, what I'm saying is this building inspector supposedly said we don't need anything to just get the heat working is what it looks like in these buildings so you can bring children in during the winter. My question to my building inspector was, it's a different use. Now it is a heated building use. It is a different use than the summer use. Whether or not it would have required, not to you, to my building inspector, an application to the sewer department. That was all I was trying to ask.
Yes,
Yes.
because it would go from a seasonal 8-week use to a full-time 10-month use.
And that
it
would
actually
require.
states that on the second page of the letter. Issuance of a certificate of occupancy for a school with 200 to 300 students on a 21.4 acre lot in the R40 district to which the 2017 tax roll assigns 10 sewer units may result in additional sewer units for which the applicant will have to pay an impact fee to the Rockland County Sewer District, the amount of $1,850 per additional unit. So they were currently not being assessed for the number of students on the site.
Well, then why did they, we're surmising, but why did they use the word may?
Because there's no CO for the current 200 to 300 students. It specifically says issuance of a certificate of occupancy. The current certificate of occupancy is for 167.
And there's no number on any of those COs.
Dan, who?
If I may, I think that the real issue of significance that you're pointing out is the fact that these, and this is what Mr. Emanuel has said, and I don't want this point to not be emphasized. These buildings were being utilized and occupied by children over the summer. That's the reason why the building permit applications that you're seeing are not for, oh, this is being, as Mr. Emanuel said, this was used for storage, now it's being used for children. No, they were being used for children. Indeed, the school population never approached the camp population. And so what you had was exactly what you would expect to have, or plumbing and other types of approvals, because that's what was occurring on the site, is simply allowing facilities that were being used over the summer to be used during the cold weather. It is for that reason, apparently, that the building inspector determined that there wasn't something additional that was needed in terms of separate approvals or going back or whatever. Now, whether or not Dan wants to argue that the village is a stop or isn't a stop, to make these arguments, not make these arguments, before we get to the legal question, we should at least try to figure out what the facts are. And that, to me, is clear as to what those facts are, and it explains the logic of why the building inspector did what he did. Now, if there was a requirement that Rockland County have some sort of an application made to it, and it was not in receipt of that application, and it wants to now come and say, you're supposed to pay an impact fee, Rockland County knows the address of my client, and they'll do whatever it is they need to do. But it doesn't establish legality, illegality, something was done properly or not. That's Rockland County's issue, not this board's issue.
We beg to disagree on how we
Okay.
say it.
That's fine.
Mr.
It may not be the last time.
Dan, who has the ultimate burden of proof, when records, if records are missing? Is it the village who's supposed to maintain those records, or the applicant who's supposed to submit those records?
Well,
I mean, right now, there are
it's
files that
sort
are
of,
open and not closed. There should have been closing documents for a number of applications, and we don't have them. From what I understand here, right? There were, applications and they weren't closed. So no file, right? So who's supposed to have that? And who pays the price of not having that?
okay. In general, just because something doesn't exist, it doesn't mean that it ever existed. So I think it's a leap to assume that something is missing here that was actually issued and just doesn't exist anymore or has been lost. I don't think
Something
there's
should have been
any
issued
proof.
that doesn't exist now, or can't be found now.
But-
Who messed up?
But how do you know? How do they know? How do you know? How do I know that it never that it either never existed or that it existed and it's now lost? It's an unanswerable question.
Well, wouldn't in the reasonable course of business have a closing document on something that's open?
Well,
No, that
closing
doesn't happen.
we've discussed the closing documents and they've agreed to.
I think they're talking two different closing
Yeah.
documents.
Yeah, he's
Yeah.
talking
Yeah.
about this building permit.
He's talking
We're
about closing out the building
closing.
permits.
Right, so there should have been something that concluded that permit, right? Denial, approval, something,
I mean, not talking about this application
in general.
specifically at all, but if an applicant doesn't complete what they're supposed to complete, it could go on and on and on. You applied for a building permit, you never got a C of O because you didn't complete what you were supposed to complete, or you applied for a building permit, you never followed up with the building department to close out the C of O.
There's no
Therefore,
termination
there's no
letter,
record of a C of O being issued because no C of O was issued.
Building
termination
permits
letter?
building permits do have terms.
right? So when it expires, there's someone who would issue a letter saying you failed to proceed with this without dismissing it.
I
Wouldn't that be a
cannot tell
normal thing?
you, I think Lou would be in a better position to answer that question.
Is anything ever issued when something fails to go further?
I can't tell you what Ian did for his building department. Currently, the way we run things is prior to the expiration of the building permit, 1 month prior, the notification is sent out to the homeowner or the applicant stating what is still needs to be done to close the building permit out.
And you would keep a copy of that?
We do.
Right.
Currently, I don't, unfortunately, after working here for the length of time that I've worked here and going through previous files, I have never seen another letter like that in any of the files. It's up to the discretion of the building inspector how he handled those permit applications. I can tell you I work in 2 different municipalities. Certain municipalities don't send out a letter notifying them of the end of a permit. If somebody takes out a permit, say, I'm going to winterize this building, I'm going to add a heating system and insulation.
Right.
Sometimes you get a certificate of completion, but no CO. Sometimes you'll get just
Or
a
compliance.
certificate of compliance, because it doesn't say what you're winterizing it for. If you told me I'm going to winterize it and store animals in it or store furniture in it, we don't really care what the use is at that point. If you tell me you're going to make it a school, there's a different set of procedures to follow. But these permit these inspections just say insulation or footings. It doesn't say what procedure was followed after that. I see no linear transgression on any of these, where it went from footings to walls to building to whatever. So I can't tell you where in it ever ended.
Okay. Dan? In general real estate procedure, when a property is transferred from one party to the next, yes, we talked about violation searches. What about the improvement on the property has a certificate of occupancy from the present owner prior to transfer? What generally happens in anywhere with that certificate of occupancy for that improvement on said property? Does that get transferred, or is it rewritten?
Generally, it does not get rewritten. I had one today where I represent a seller, and the purchaser's attorney called me up and said, I heard that your client put in a patio with rocks, which is basically on the ground. When was it done? I called the client. They said it was done in 2005. It turns out that anytime you put a patio, this is something that you may not even know.
credits?
Yeah. If after 2015, this is also important for anyone in the audience. After 2015, as a result of the stormwater management regulations, I admit, I just found out today, a patio has to get building permit approval and show a drainage system which will accommodate that. So, once again, I represent the seller, had to confirm with the client, asked them to provide me a copy of the receipt from the entity that did the work for it to prove when it was done. It turns out it was done in 2005, which is grandfathered, so he didn't need to go further. But this is what we do as real estate attorneys if we're doing our job. We look to see what C of O's are required. Do they have the C of O's? If they don't have the C of O's, it's incumbent upon us, and we know about it, it's incumbent upon us to get those, make sure that the seller gets those C of O's, or we don't close.
All right, in this case, Mr. Emanuel, what took place upon transfer of ownership?
He doesn't know. He
I wasn't the attorney.
You weren't the attorney. So this is a piece of information that may be important to this board.
Well, we've already been asked to and have agreed to provide you with a violation search.
Talking out loud, want to be fair here, because building inspector is stating for the record that the property is permitted for 167 students. We've had a use of 200, 300, 400 students, and violation was given because population went beyond. So we're missing that piece of, I'm just talking out loud here, we're missing that piece of information.
I'm not sure. We'll look, Mr. Chairman. We'll find what we can and we'll provide it to you, as Mr. Emanuel said. But I think that there's an assumption being made here that at least I don't agree, which is what a private property owner chooses to do at a closing, whether or not they choose to or don't choose to, or look at or don't look at a certificate of occupancy and violations. By the way, title companies provide that service, as I know council knows, at the request. It's not part of the title report itself. Right. It's a convenience that's provided while they're doing other things.
I'll even go beyond that. When they provide it, they do so, what's the exact terminology? For informational purposes only.
Right.
That's right. So
And then they charge sales tax on top of it.
And you pay to insure it.
My point is that regardless of what was shown or not shown, maybe it'll provide a document that we have been missing. That would be nice. Whatever the document be, good, bad, or indifferent. But other than that, whatever the title, whatever the property owner chose to do in terms of closing or not closing, no, there's no issue or inference about whether or not the prior building inspector acted legally, didn't act illegally, and whether or not there's a violation here. So we'll provide the record for purposes of completing the document record, but I don't want to let it be assumed, at least from our perspective, that there's any relevance to this in terms of your legal decision.
Thank you. Okay.
Sir?
Well, is this appropriate?
It's not a public hearing. I will leave it up to you to ask the applicant whether or not they would object. If they object, it's not a public hearing. Public meeting, it's not a public hearing.
Right. Mr. Emmanuel?
If you want to accept public comment, that is entirely up to you, and we have no objection.
All right. I respect my neighbors.
Thank you. Just
Could you just tell us your name
sure.
and I won't even sway
Ethel
you?
Rosen, 22 Van Gogh Lane, Airmont, New York.
Okay.
Been a resident 46 years. My question, since I'm a former school teacher, just point of information. How many classrooms are you talking about? How many, you're talking math. How many classrooms are we talking about? How many children in each classroom? How many desks? What's the evacuation? You're talking in mass. I'm talking about, we just had a fire last week in some other. I'm talking about safety. I'm talking about books. I'm talking about programming. I mean, let's take the whole gamut of it. How many classrooms?
I hear what you're saying. The board here is charged with interpreting a violation, the intent of the violation, whether it was appropriate, that was imposed upon the applicant by the building inspector, and we're hereby noticed to go to court to deal with this. These issues are ultimately important because we all want to preserve the safety of people.
Right, so that's,
I
you're
agree with
talking
you on
in
that, but
math,
it's-
and the logic of the average person like me, you're talking 400 kids. How many in a classroom? How many classrooms? How many bathrooms? How many exits? All of the safety of the individual.
I appreciate what you're saying, and those issues are addressed by our planning board. And again, our focus here is so very narrow here this evening. But you're absolutely correct in having, brought that up. And it's not gonna not be addressed for this property or any other property.
I'll add that, in my opinion,
Yes, please.
my experience with the applicant at CDRC, that is first and foremost on their minds as well, is the safety of those students.
Appreciate that, thank you.
Ma'am, your name, please?
My name is Melissa Girardi. I would like to just point out that I was at the May CDRC meeting with this applicant when they were asked how many students they had. He said between 200 and 300, which immediately said to me, like, we don't know if there's 200 or 300 children, so if there is a fire, we're going to save 200 children and maybe 100 children are going to be trapped and burned to death, whatever. But that was not for public comment. I came back to the CDRC meeting in July. The same applicant was back, and when they were asked at that time how many students they had, they said between 300 and 400 students. So it concerns me that they're not being as forthcoming or as transparent either. They don't know how many students they have there, or they don't want us to know how many students they have there. So I just wanted to point that out.
Okay. I won't touch that, but I appreciate the comment. Okay, any questions?
I just have, I'm just looking at the July 19th, 2001 resolution. It clearly states there the maximum number of students to be enrolled at any given time should not exceed 167 students.
What document are you referring to?
The resolution.
Resolution from July 19th, 2001.
The planning board.
planning board resolution.
Yeah, I
Mhm.
just
I
wanna
guess my
get
question,
that,
if you, what would be the procedure, and maybe this is a procedural question, if you wanted to increase the amount of students, what would the procedure been done to accomplish that?
wouldn't that be, a reapplication to the planning board?
CDRC and then planning board.
CVRC, the Community Design Review Committee, and the Village Planning Board.
Prior to any
So looking at
increase?
the whole ball of wax over again and considering the increase in, student population in relationship to facilities provided, et cetera. So that would be the way that would happen.
Yeah, again, the language is should not. The language is not, may not. It's not directory.
For the safety of the child.
Okay.
I guess that's open to interpretation.
That's why we're here.
So
Mr. Chairman,
where do we go?
well,
Where do we
in
go
due
from here?
respect to everyone here, and as the applicant is well aware, this 99 package plus every other piece of paper has had minimal time for review.
Acknowledge.
Okay, and as much as we want to make sure that our decision is forthright and unbiased, we also need to make sure we have all information that would be based on this. One of the things that I was trying to do electronically was to put all the permits and throw things together to see what I came up with. It looks like the last ones were in 2014, and that might have been for a deck ramp. So I really, out of due respect, would like to see if title had. Now, real estate is something I know a little bit about, and the investment price of this property I know a little bit about, and the wiseness of the applicant I know a little bit about. So I have to assume research and due diligence was done. So perhaps we're all running around in a circle that title may have some answers for us. So I would like to recommend that we do not decide anything until A, we see if title has any answers, B, the members can absorb the amount of information in front of us.
Well,
In that vein,
let's see, we said we were
I would
done.
also request, since we are gonna provide additional material, this submission was pretty much confined to facts and background documents and so forth. And I think we would appreciate the opportunity to perhaps put in a submission that would address some of the legal issues, the building inspector's authority, some of the things that were said tonight in terms of the current building inspector, and address some of the legal issues, as
Maybe
well.
you wanna bring the former building inspector next time too.
I mean, I look at the, I trust that interaction with Ian Smith is, as you're calling it, well known to me. I have no reason to doubt it whatsoever. Whatsoever. However, it's still, I don't wanna use, it's not hearsay, but it's, you may wanna ask Mr. Smith to,
I will take that under
look us in
advisement.
the eyes if he would do that.
We will also take, if the board is going to be continuing this to another evening, as it appears that that's going to occur, we'll also take the and I'm sorry that you're behind that list there. Please be Mr. Gillespie.
This is Ms. Carbone, she is,
She's the deciding vote.
We will also try to continue our efforts. I have contact with Rob, I think. He happens to be a client of mine as well. And I'm actually scheduled to speak with him tomorrow on another matter, and I will reach out to him again to see if I can get to his records.
Dan, I believe the board is, I can feel it, is probably together on continuing this discussion as soon as the next meeting. Appropriate? Given the short time for review,
The next meeting is
request for additional information,
February 8th or
March 8th.
March 8th.
March 8th.
So pick your 8th.
pick your age.
depending on how much time you need to compile everything.
The title report would be either, the applicant
Yeah,
can
we
get
can
a
get that
copy
to you.
of
We
the
can get that
title,
to you
that's
quickly.
easy.
Yes.
Would you like the next, scheduled meeting of the zoning board?
I think it's probably a good idea, and if we feel that we need more time, or if the board feels it
Right,
needs more
contact the
time.
clerk.
Right.
We'll,
And
We'll
she'll
talk
contact
amongst
me and I'll
ourselves.
probably say what you feel is appropriately fair. Because we're fair.
Mr. Chairman, you and I have dealt with one another many, many years.
We just
I,
wanna
I,
be
I,
fair.
I know that you and the board members have always tried to
I
be fair.
just want you to know, with respect to our building inspector, I have confidence, in his diligence in reviewing and going after all this tremendous amount of information and given that he wasn't in office during all those years. So I want to appreciate for the record his efforts in assisting us here and trying to get to the bottom of this thing. So we would
Close it.
about
I would just like the applicant, if possible, to bring in any of the current records since they have been owners there. We appreciate Mr. Fink. So the inspections and everything that have to do with this site currently going on that the applicant has been recording for the last 2 years, showing, I don't want to say almost like it's a grandfathered place. Terry's was one business. You're another business. What happened there and what happens with you, you're not responsible for them, they're not responsible for you. So anything that's been going on as far as inspections, I saw fire inspections, but I didn't see for 2016. I didn't see any of the showing the school numbers and everything that you were showing in the past. So if you could possibly produce that with before the next meeting, I would appreciate it.
We did have an inspection at the end of the last school year, but we ran into this issue that the amount of kids became a question, so we never got any resolution. We got recommendations from the fire inspector on certain things that we did fix, but we never received any certificate because the building inspector and the fire inspector said that since they don't know how many kids are allowed, they can't give us any interpretation on that, so that's what it is.
Let me just check with the building inspector. We had building and fire inspections that said items had to be corrected. Okay. Am I understanding that we're refusing to go back and see if those items are corrected?
That's not true.
Yeah.
They
Thank
did,
you.
they did
No,
come
that's
back,
not-
but I
that's
didn't,
not what he
I
said.
didn't
That's
that's
not
what
what he
I'm
said.
trying
they
to
Why would
didn't
you
understand.
issue
doing
any
that?
paperwork as of the finish of an inspection, rather if it is a certificate or not.
Actually,
Thank
go
you.
ahead. There were building safety certificates issued for several buildings on the site, just not all the buildings on the site.
Okay. That's what I'm saying. We can just have complete records.
And for the record, those buildings for which safety certificates were not issued are not being occupied.
let's get a,
That's what I'm saying, just so we
Okay,
show.
that
because
writing,
the
We
board
do-
has-
we do
the
care
board-
for our
the
children
board-
very
the board-
much.
Yeah, the
We
board,
do
the board,
care
the
of you
board
very
has
much.
expressed concern about safety, members of the public have expressed concern about the safety. The school is compliant with all of the safety requirements.
alright.
And we take it from our council very much aware of the concern that your client has. We're just trying to get all the paperwork that we
Understood.
can.
Understood.
And also, one last thing you could help us with. I'm sure as a school you have registration. I'm not asking for names, that would be confidential. But can you give numbers and the grades of the students that are there so we know what this population is comprised of? Is that
We will
feasible?
give you.
That way there won't be, is it 2 or 3, you have a registration. I'm sorry, Mr. Chairman.
Are you really?
I really am.
I'm just asking if you were really sorry.
I really
You're
am.
just being plain sorry, may not be enough. I don't know.
I know, I'm informationally sorry.
Okay, I accept that. Alright, so in summary here, alright, we got somewhere, but, we need to, conclude. So we will conclude, hopefully, at the next regular meeting of the zoning board of appeals, which is on February 8th.
February 8th is the
At
next.
8 p.m.
At
At
8
8 p.m.
Unlike tonight at 7:30.
Because we had some,
Right.
And if that is too soon for you to get the data, the
We'll
next
let you
meeting
know.
is March 8th, and you let me know.
We'll let you know,
And I will
and we'll
convey-
try to let you know sufficiently in
That's
advance
fine,
to give
and I'll convey to
appropriate
everyone.
notice.
Mm-hmm.
Right, it'll take a month to read this.
all right,
How we put this together.
I'll make a motion to adjourn.
wait. Let me just see if there's any, no, there's number 7 on the agenda. Is there any new business members that you may care to introduce or not? If not, then I'll hear from Mr. Kent. What was your motion?
My motion is to adjourn.
Is there a second?
I'll second.
All right, all those in favor?
Aye.
Aye. Thank you, Mr.
Thank you for your
Rogers.
time.
Oh, thank you.
Yeah.
Thank you, thank you.
I gotta figure this out.